Good afternoon. Boy, it's good to see a lot of old friends here. I feel like a spectator at a Brain Injury Hall of Fame meeting here. Many people that I've spoken with over the years. I haven't seen you in quite a while. I haven't spoken on this subject in a while because I went off and started doing mass torts. I didn't have enough challenge just trying to handle a simple brain injury case. I had to go take on 10, 15,000 clients at a time. I've been talking on this subject for about 30 years now, and I'll hasten to say it's not the same speech, it's just the same topic. But we've come a long way from back in the 80s and late 70s when we were trying to establish that PTSD actually existed. And we had so many cases where Dr. Larry Pollack and Dr. Ralph Lilly and we'd be trying to prove up that there really was such a thing as a mild brain injury that didn't show up on any of the radiographic testing. So we've come a long way from that. Unfortunately, through the military, we've had the bad experience of seeing that come to the fore with the PTSD, and now through the NFL and all the concussions. But we've come a long way in a lot of other aspects of it too. And I want to mention what we used to try to prove as the misnamed mild brain injury that we had a lot of those cases back in the 80s. I'd be hard pressed to take a mild brain injury case today in Texas because of the difference in the jury, the makeup of the juries, and the requirements of proof. But we used to make the arguments. I know our favorite thing on the mild brain injury was we'd stand up and say on voir dire examination that the defense theme in this case is that if you can't see it, it's not there. If you can't see it, it's not there. Now, this is an injury that doesn't show up on MRI, it doesn't show up on CAT scan, it doesn't show up on x-rays, it only shows up on autopsy. So then we start out voir dire by asking, now, are there things in your life that you can't see, but they're actually, you know they're there, they do exist? And they'd come up with things like oxygen and things of that nature. So we'd take away that defense right off the bat on voir dire examination. But then we'd have to go through the whole process of overcoming the fact that the neuropsychologist is not an MD, but he'd say, no, I'm the person to whom the MDs refer their brain injury patients when they have this type of injury. So I want to talk to you about something a little different today. I want to go back to the basics of what is our message, how do we couch it differently today, but mainly about the demographic target of our message, because that has changed so much. It's changed. We used to try cases to the boomers, and the boomers awarded a lot of money in our cases. And then along came Generation X, and Generation X they were the tort reform generation. They were the perfect target, demographic target for the tort reformers, and it worked. It worked in spades with them. And so we took a big setback with the tort reformers, with Generation X. But now we have a new demographic that are the targets, and trying a case today to the dominant members of our jury is different than it was 30 years ago, 20 years ago, or 10 years ago. So I want to talk to you a bit about that. So let's start with just the message and our approach to the message. We have the messenger, the message, your means of delivery, your audience, and then how the audience processes the information. Now, we as attorneys focus on the messenger, which is ourselves, our expert witnesses, the people that we're putting on the stand, the message. And in focusing on our message, I've always believed in Einstein's statement that make everything as simple as possible and no simpler. So we have to go with simplicity on our message. Because brain injuries can be complicated enough without us unduly complicating them with a complicated message. Our means of delivery, I'm going to show you some things that we devised in terms of visual evidence, in terms of means of delivering our message. But then the real message itself is determined by the audience. What message do they receive? And what message do they process through their brains in arriving at their conclusions? And a lot of times there's a fundamental disconnect. When you lose a lawsuit, when you lose a brain injury case, you find out, and I've lost brain injury cases, and I've debriefed jurors afterwards, and I found out that there was a fundamental disconnect between the message I thought I was delivering and the message they were receiving. So the way to avoid that, the way to reduce the likelihood of that occurring is through focus groups. You want to make very sure that the message you're delivering, or you think you're delivering, is the same message that they're receiving and the same message that they're processing. And then how are they processing it? So you do that. The processing, remember, this is something that's had a slight change too. This is very old data here, but there's a slight change in this with the new juries we have. When we're delivering messages, our message is delivered, the verbal communication that we use, the words we use, is only 8% of the delivery of the message. That's not to say that words are not important. Words are vitally important, vitally important. And we work with focus groups in arriving at the right language of the case for this particular case. What are the words that they use? We put our message out there in plain vanilla presentation, and then we listen to the language that the focus group uses in how did they describe the injury? How did they describe what's going on in my case? And then we try to use their words and the words to communicate with the jury. Vocally, 37% of the delivery of your message. And the vocal communication has become, along with the verbal, has become less important. And I'll tell you why in a minute. But the vocal communication is the sincerity in your voice as much as anything else. The fact that you're confident, you sound, this is important, you sound as if you believe what you're saying. You sound as if you are sincerely conveying a message in which you believe. Because if they get the sense that you're just a hired gun reciting a message that you're paid to recite, if you don't believe it, why should they? So the first proposition is, if you don't believe in your own client's case, if you don't believe in the case you're trying, then get the hell out of the way and let somebody try it who does believe in it, because it's a vast disservice to your client for you to stand up and try to convey a message or a case that you personally don't believe in, because through nonverbal communication, through vocal communication, the jury will pick up on that and they'll punish your client for it. So vocal communication is 37% of the delivery of the message. Now, this leaves 55%. Nonverbal communication is 55% of the delivery of your message. Now, nonverbal communication includes all the visuals that we're going to talk about. It includes all the things that they see with your client as they're watching your client. And one of the major problems you have in a minor brain injury case, I even hate using that term, it's an absurd term, but one of the things they see in a minor brain injury case is when they sit there for 4, 5, 6, 7 days and they watch your client, and they watch your client during the breaks, and they watch your client in the hallway, and they watch your client all over the place during 4, 5, 6 days of trial, and your client appears perfectly normal. They see nothing. So that nonverbal communication, 55% of the delivery of the message. They watch the relationship between you and your client. They watch the relationship between the client and between every witness. So they're always reading nonverbal communications of everybody. So we tried, in trying brain injury cases, I always try to not have the client present for the trial. And I don't have them present for the trial for just that reason. I'm talking about the person who is not visibly hurt, injured, brain injured. I try to not have them, and the reason I get them excused from the trial is I would go to the court and say, Judge, my neuropsychologist will tell you that it will be detrimental to the client to sit there and listen He's been into therapy, he's been in rehab, and if he sits here and listens to 5 days of testimony about how brain injured he is, it's going to be very detrimental to him. So we bring the client in and we introduce the client to the jury, and we have the court explain that the client is excused from being in the courtroom because of what his doctor said. And then we have the doctor explain why the client is not in the courtroom. So we bring them in, and they see the client, and usually the client, if they testify at all, will give the briefest testimony of anybody in the case, because you don't make a brain injury case through the brain injury client's testimony. Then you come to the message is the message that's received, and the message is the message that's processed. And by process, we mean people process our messages in 3 fundamental ways. They process it auditorily with what they hear. They process it visually with what they see. But then they process it kinesthetically. And kinesthetic processing means that this is the nonverbal communication. This is where the unconscious mind, or what Kahneman refers to now as the slow thinking mind, is perpetually gathering information. And so they're gathering information that may be adverse to your case. They don't realize they're gathering information that's adverse to your case. They don't realize it's adverse to your case. But the unconscious mind is gathering all this information. And that's what happens when you have a traumatically brain injured person sitting there in the courtroom with you who looks perfectly fine. Every day they're gathering information that this person looks perfectly fine. And so that doesn't set well when they start trying to evaluate damages and the nature and extent of the injury. So, but the kinesthetic processing is what happens when they get in the jury room and they say, you know, I heard the plaintiff's argument, and it was very compelling. It was very persuasive. But you know, something about this client's case just doesn't feel right to me. And that's the kinesthetic processing, which grows out of what they gathered in nonverbal communication. So that's why Eric Oliver, who's a great trial consultant, told me one time, and I couldn't understand this for a while, but it finally sank in, that don't ask a juror why they decided the way they did, because they don't know the answer. And the reason they don't know the answer is because so much of the basis of their decision came out of the nonverbal communication, out of what they saw and what they processed in the unconscious mind. They don't even realize that's why they made the decision. So Eric says you don't ask them why did you make this decision, or what was your basis for this decision. You ask them a lot of other questions. There are ways to debrief them and get the same information. But they really don't know exactly why. So a couple of obvious issues. Effective visual evidence increases the probability. There are 3 things here. With powerful visual evidence, you increase the probability of your evidence being received, of it being processed, and mainly, and this is most important, of it being recalled 2 to 3 weeks later in the jury room at the time of deliberations. So you're going for 3 things: receiving the evidence, processing the evidence, and recalling it at the proper time. As we know, jurors may interpret oral testimony differently than the witness and the attorney intend. They also may perceive visual imagery differently than intended. This is again why we test everything, especially our visual evidence. We test it all before focus groups. They can tell you, the focus groups can look at your evidence, and we put our evidence in there in focus groups and just tell us, what does this mean? We don't tell them what it means. We don't tell them what we intend for it to mean. We put it up there and let them tell us what it means. What message do you receive from this? So we test the graphics not by getting them to agree with us, but by letting them tell us if we have conveyed the same message to them that they're receiving. So, jurors attempting to recall, this is important for visual persuasion, because we know from forensic psychologists that when jurors are attempting to recall evidence in the jury room on a specific issue, mental anguish, physical pain, whatever it is, they'll search their minds first for visual imagery. So if they're going to search first for visual imagery, there's all the reason you need to have powerful visual imagery as part of your trial in every type of case, but particularly in brain injury cases. A combination of visual imagery and credible oral testimony is key to them receiving, processing, and recalling vital information. So what you do is you combine these together, and the whole idea now, Jerry Spence said it first, 30 years ago. He said, it's all about storytelling. It is all about storytelling. Jerry's absolutely right. So you're combining a story, you're combining your oral presentation with your visual presentation in putting it together in a storytelling format so that you're telling a story to the jury right from opening statement on. You're telling a story to the jury about what your client's case is about. Why? Because we all like stories. We're conditioned to stories. Our life experiences are filled with stories, and we all make decisions and based upon our life experiences. So we're tapping into something that they're quite accustomed to. The next thing is support your outcome. You figure out what your outcome determinative issues are. Then you figure out what your themes are that support reaching the right outcome in your outcome determinative issues. And then you combine that with visual evidence that's tied to the most credible testimony. Let me tell you what I mean by that. You combine your visual aids and use them to control the juror's focus because they will attach to something that, and if you can keep your visual aids in front of them, the longer you can keep them on the stand, the aids, the longer you can keep the visual imagery in front of them, the better off you are. Because it becomes more indelible, obviously, more memorable, and easier to recall at the vital time. Now, you enhance it's a combination here. You look at your visual evidence, whether it's an x-ray or whether it's something you created, whatever it is, you look at your visual evidence and say, which witness lends the most credibility to this graphic? Then you look at it from the other side. Because in many of these you'll have several different witnesses that you can choose from in terms of who should I use to put this on first, to introduce first. You can use it with several different witnesses, but who creates that first impression with this particular piece of evidence? Then you look at the other side and say, which graphics, which visual evidence will be most helpful to enhance this witness's testimony or to aid this witness in their testimony? You know, we have witnesses who are absolutely terrible. And so, there's nothing you can do to change that. We take our plaintiffs as we find them. And sometimes you just get stuck with bad witnesses. So what you can do with a witness is you can make life easier for them by giving them graphics which help them explain which reminds them of what their testimony is and helps them tell the story that they're on the stand to tell. The same thing with expert witnesses. Jurors love educators. So when I get an educator on the stand, then I want to get him or her off the stand, and I want to get them down on the chalkboard, and I want to get them pointing and explaining and taking the graphics that I have and explaining what every single thing means. And I want them to be down there in a position of an educator. When they leave the stand, they seem to lose they don't lose the position of a witness, but they add the position of an educator, if you can get them down. So if I can get Ralph Lilly off the stand, Ralph's a great witness, but if I can get Ralph off the stand and get him at a chalkboard or get him up at a piece of demonstrative evidence to explain what this means and then what this means and what this means, he's now a great witness and an educator. And we all like to learn about, especially about medical things. So you try to enhance your witness with a graphic, and you try to optimize your graphic with the witness. So you put that combination together. The next thing is there's availability is one of the most powerful of all the biases, and all I think Kahneman has like a whole chapter on it. What availability says is this: the jury will focus in deliberation where the spotlight was placed during trial. Availability is a huge advantage to the plaintiff because we get to decide where the spotlight is placed. So we should put our spotlight on the liability of the defendant and on the damages of the plaintiff. Now, today, things are tougher than they used to be in the 70s and 80s when we tried these cases in terms of responsibility of the plaintiff. Tort reform has raised the suspicion that every plaintiff is faking. You know, come on, you're faking that coma. Sit up. I mean, seriously, we got some tort reformers in Texas who would do exactly that, which is why I'm doing mass torts in New York and Massachusetts now. But we get to decide where the spotlight is placed. So you remember when you're putting your evidence together that you won't focus. This is a rifle shot. The trial now is very carefully placed sniper shots. The shotgun approach doesn't work. Just let's throw everything up against the wall and see what sticks. That doesn't work. So you want to get focused. You're always trying 3 cases for damages. I always think in terms of compared to what. The condition of my client today is this compared to what? Compared to what this client was before the injury. And then you're also trying what is the future of this client going to be like. So you're trying 3 damages cases. But just putting a client on and talking about their condition today it doesn't have near the impact as it has if you prove the complete case of who this person was before, and what they could do before, and what their life was all about before, and what their capabilities and what their hopes and dreams and aspirations were before. Then you compare them to where they are now, and how many of those hopes and dreams and aspirations don't exist anymore, and then you talk about the life care plan of what they're going to be like, what their life's going to be like for the remainder of their life expectancy. This is just by way of just showing some injuries to this fella. He had all kinds of injuries, but they were questioning his head injury. And so they said, no, he didn't have it. We'll give you the fractures. Guy was hit by an 18-wheeler. And literally, he was hit by the 18-wheeler. He's a passenger in a vehicle where the bumper of the 18-wheeler caves in the door where he's sitting on the passenger side. So I brought up all these others to show the impact, but then here's the before and after. And the thing in the middle, I did a hologram. Here, I'll show you. We did a hologram of his facial injuries. And we said, okay, and it was 60 inches. It was 5 feet tall and 40 inches wide, this hologram. And it's 3D. You just look right into it. And I walked in, the defense lawyer walked in, and he said, damn, I didn't think you were going to spend your entire fee on one exhibit. And I said, no, my fee just went up way more than the cost of this exhibit. So, but how can you look at that? How can you look at that man's face? How can you look at every bone in his face literally being fractured and think that, oh, by the way, the bumper of that truck just may have impacted his brain ever so slightly as well? You see, that's proof. That's evidence. I include this youngster in here just because I admire him so much. He's one of my all-time favorite clients. But this is how you project your client. You don't ever project your client with sympathy. You project your client with this. And this is not a brain injury case, but this is a paraplegia case. But this is how you project your client. You project your client with courage. This is a young man who's doing the very best he can with what he has left to work with. And that's always been my favorite picture for for how we should be setting our clients up and selling our clients to. Before and after, here's a young man who's brain injured. This was him before, bright-eyed kid with a very bright future. And then we hear about a 3 on the Glasgow Coma Scale, but we need to see what a 3 on the Glasgow Coma Scale looks like. This is a young man who's 3 on the Glasgow Coma Scale. I know you're familiar with the Glasgow Coma Scale. It runs from 3 to 15. At 15, you're phasing in and out of cognizance. I think it's at 8 where you can be the claims manager of a major insurance company. And obviously at 3, you can be governor of the state of Texas. In fact, I think it's become a job requirement. Okay, here, I'm showing you these by saying sometimes you don't have to run out and spend a bunch of money. These photos tell the story. Start with your family photos, okay? Here's a young man. This was a case I had in Utah, and this young man is brain injured, obviously. That's a picture of him in the upper left-hand corner before. The picture in the lower left-hand corner is the young man and his brother before. One of the most compelling piece of evidence I've ever put on the stand, ever, was this. The parents of this young man, it was a Radio Shack manager in Utah, and he had recorded this, and you talk about a powerful piece of evidence. 2 years after this picture down in the lower left-hand corner was taken, I have a picture of the younger brother, the baby brother, reading a storybook to the brain injured. I mean, it made me want to cry to see it. If you thought I cried, you should have seen the defense lawyer. But it's one of the most compelling pieces of evidence I've ever seen. I want to go into this way for a few minutes. I want to tell you why. This is the recipient of the message. And the recipient of the message, our target demographic of our message, is considerably different today than it was in the 70s, 80s, 90s, or even in 2000. Okay, because for this reason, we have all this current sociological, generational data, demographic research. This is the Generation Y, the Millennials, are the most researched group in history. There's more data done on them than anybody in history. For one thing, we have a lot of forensic psychologists with nothing else to do. But so they've gone into this heavily. But look at this jury pool. Your jury pool, the boomers, who awarded us big money in cases back when they were running things, 80 million of them. Those folks are almost all smart enough now to know how to get out of jury duty. Generation X were the tort reformers. These were the people who created, they lived with personal responsibility. Personal responsibility was their theme. The millennials, though, look at this, 75 million of them, and they now dominate our juries. In most jurisdictions, especially in college towns like Austin and places like that where you have large communities, they dominate the juries. And they're polar opposites. Now, who they are, the reason they call them millennials, they call themselves the millennials. They started out as Generation Y. They said, no, that we're not Generation Y, we're the millennials. The reason they call themselves that is because they graduated from high school in the year 2000. So they were born from 82 to 2002. They're the children of the boomers, and they're the siblings of the Gen Xers. They are, now notice this. This will tell you a story. 94% of them have cell phones, 76% have instant messaging, 92% multitask in messaging. What is that? It means that they're all interactive. They're all perpetually tied into technology, and they're all perpetually interactive. What they don't have is conversations with each other. They don't talk to each other. I have literally seen them sitting across the table texting each other. And I had a group in Vegas. There were a group of us, and we had about 10 of us had a cabana out by the pool in Vegas at a conference. And I saw these guys over here are texting and laughing, and these guys over here are texting and laughing. I finally figured out these guys are texting each other. And they're sitting this far apart. And I said, you guys realize you can hear each other, right? They don't care. I mean, they'd rather text than talk. That's the millennials. So the point is you get a dominant group of millennials on your jury and you put on oral testimony and that's all you put on, or you don't engage them. You have to engage them. You have to involve them. You have to make them interactive. You have to be interactive with them. If you don't, you're not going to lose them. You're never going to get them. You'll never get on the same page with them. Now, let me tell you the good news about the millennials. They're the second largest population, 75 million. Here's how they self-identify. They're more liberal. They regard themselves as progressives. They're more Democrat than any generation before at their age. A lot of this has to do with Obama. A lot of these folks had a lot to do with Obama being president today because he carried the millennials across the board. And he also carried, that's where his $50 fundraising came from. He had college students all over the country giving him $50 online and raised massive amounts of money. 50% of these folks are entering college. Now this is important for us to understand because here's how we do reach them. They're accepting of authority. They are rules followers. And they're the most supervised generation in our history, and rules of the road are very important to them. So if you are trying a case to a group of millennials, rules, 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 rules. That's all they've known their whole life is rules. They follow rules and they accept it. They're okay with it. So if you have a medical case where a doctor has broken the protocol, the doctor has broken the rule, then you want to, whatever it is, if it's a product liability with a design defect where they broke a rule of the, or whatever it is, manufacturing, whatever, you prove the rule. Now I say prove the rule, I didn't say stand there and talk about the rule, I said prove the rule. You put the rule up, you put it up where they can look at it. I don't care if it's speeding 70 in a, excuse me, in a 55 mile an hour zone. You put up the rule on speed limits. And you establish the purpose of you establish the rule, you establish the purpose of the rule, then you establish the demographic group which the rule was designed to protect, be it patients, consumers, whatever it is. Then you establish that this doctor, this designer, this driver broke this rule and injured this party that this rule was designed to protect. Now, when you prove all that, then you go one step further. You prove how many different choices did this defendant have, how many different ways could they have done the same thing that would have avoided the tragedy? So you show the rule, and then you show he could have done this within the rule, he could have done this within the rule, he could have done this within the rule, he could have done all these things. And the more choices you can show that the defendant had to avoid the tragedy, then you start exacerbating damages. That's when they start, there's an effect that comes in there which causes them to, they take it out in damages. That if you've got it, now, if you get into a malpractice case, a medical negligence case, to prove that there was a rule, and that's the only, that this is the choice the doctor had that was right, then he's going to come in with 18 of his cohorts in the medical profession and say, no, there's another rule over here that's just as acceptable. So if it's a one-on-one thing, and he's got all the expert witnesses, so if you're in a medical negligence case particularly, you want to show as many different ways that the doctor could have done this diagnosis or test the different testing they could have done and all that sort of thing, as many different choices that the doctor had which would have avoided the tragedy. But if you've got a rules violator, they're all over it. This is your group because they are born and raised with rules. Now they self-identify. This is important for us as to how do they think of themselves. They self-identify. First of all, they have a positive attitude, which is true. They're very outgoing, positive as a general proposition, whereas the Gen Xers were sort of down on themselves because everybody else was down on them. They called them the Generation X because they had no identifying cohort that tied them all together. These folks have a lot of them. but they have a positive attitude. They're cooperative team players. They work together. They love to work together as teams. Why? Because their whole life is on teams. You know, when I was a kid, if we wanted to play football, we'd get the kid that owned the football, and we'd go out on the field and we'd start tossing the ball around. Next thing you know, a few more would show up, a few more would show up. Next thing you know, we'd have a football game, just from the kids in the neighborhood. Now it's all Pony League, Pop Warner League. Everything is a league, and everything is a rule. Everything. They have managers. They're supervised. They're supervised when they play, for God's sake, and then everybody gets a trophy. So but that's their life. Okay, so but the result is that they like being in rules, and being in teams, and they're cooperative team players. With that in mind, when you are trying a case involving Gen Xers and Gen Y, but especially the millennials, you want to watch how they congregate during the breaks. You see who's together in the halls. And the millennials hang out in the halls, and then you'll look and you'll see, okay, there are 4 of them there, but every time you take a break, this one guy's doing all the talking and the others are listening. He's your leader in the jury room. Same guy that leads the conversations in the halls is going to be the same guy that leads your conversations in the jury room. So you keep an eye on them and see. They're team players, so who's the leader of their team? They're very accepting of authority. They're the most supervised in the history of the universe. When I was a kid, when I was 6, 7, 8, and 9 years old, we'd go out in the morning. In the summer, we'd get up in the morning, we'd have breakfast, we'd go out and we'd leave the house. And the rule was, we had a staunch rule. We had to be home by the time the street lights came on at night, which was 12, 13 hours later, okay? Now, if they leave the house at 9, if they haven't texted or called back in by 9:15, there's an Amber Alert. They're the most supervised. They don't do anything on their own. And you have to realize that with them when you're trying a case to them. These are the people that you're putting your client's future in their hands. So you need to understand them. Now, remember, this is self-identifier. They think they're smarter. And they are, because of technology, because they know more. They start with computers in the crib when they get home from the hospital, and they're smarter than everybody else. How does that impact in the jury room? It impacts in this fashion. They're not going to listen to Gen Y. They're not going to listen to Gen Xers. They're not going to be persuaded by the boomers. They're not going to be persuaded by anybody in the jury room except each other, because they think they're smarter than everybody else. So these people are very, very important to us. They're progressive, which means that they have compassion, and they can be more they will be more compassionate to our plaintiffs than the Gen Xers, whose attitude basically in Gen X, and they had good reason for this attitude. I'm not criticizing them. Gen X had the attitude that, why should I do anything for you when nobody's ever done anything for me? I did it all on my own, which is where self-reliance became their big theme. They are cutting edge. So if they're cutting edge, and this is especially to do with technology, then you need to be cutting edge too. They're going to pay attention to the lawyer who is cutting edge also, because you're on their wavelength if you're cutting edge as well. They're better educated than other generations, and they are global in their outlook. They don't, we knew the kids on the block. We knew the kids down the street. They communicate with kids all over the world through the World Wide Web. So when you're proving your brain injuries to a jury now, and when you're talking to a jury of Generation X or Generation Y, we prove everything, every aspect, every little aspect of a case. There's a mistake that I've seen lawyers make for years, and I've railed against it for years, in that when you have a large injury, you have a substantial injury, you have a tendency, like if you have a paraplegia case, for example, you have a tendency to forget all the other injuries and just focus on that paraplegia case. So what I would always do when handling paraplegia cases or anything else is I would take one of my associates and I'd say, okay, your job is to prove up every injury to this patient except the paraplegia. So you take this patient as if they have everything wrong with them except the paraplegia. So then you get all those small injuries, they have a way to add up. So in a brain injury case, we like to show everything that indicates a contributing factor to a brain injury. So here we're talking about damaged brain cell. Now we have a left skull fracture. Okay, then we prove the left eye scalp laceration. These are not big things in and of themselves, but they're all just, again, indication of the blow to the head. The periorbital laceration. And then we get the injuries, we get these blown up, and this is post-traumatic polycognitive deficits of memory, judgment, insight, and executive function. Then, when you want to engage the jury, you want to educate them, the question about how can you get hit on one side of the head and have injury on the other side of the head, which we know as diffuse axonal injury. So we created this graphic to illustrate that point. Now this is where you put your doctor on the stand, and I mean the doctor's up there by the picture, and he's pointing and he's saying, okay, you get the blow to this side of the head, the brain collides with the skull, it shoves across, the brain collides with the other side, and then this is the part where you want your doctor being the expert. You can freeze frame this anywhere you want to while the doctor explains what the axon is, what the neuron, the myelin sheath, and he shows the transfer and then shows what happens. Now you'll see the bump here. Okay, that's where the shearing occurs. That's where the blow to the head occurs. And now you have the axonal shearing, and you no longer have the compromised signal. You have a compromised signal transfer, so you no longer have the normal transfer of information. Then the doctor follows up on this by saying, okay, what does that mean? What is the effect of that? That's a nice graphic. Okay, so you have compromised signal transfer. So what? So now your doctor just takes the next step and explains, well, here's what happens as a result of that. Here is what happens functionally to the patient as a result of that. So we cover those injuries, and then we go to film, and we do an MRI of the brain, and you walk through the injuries as they occur here, and you go deeper and deeper into the injury, and then here's the MRI of the brain. Now you have to understand that with this child, the neuropsychologist, the defense neuropsychologist who did the examination on this child, his finding was that this child suffered a tendency to stumble, which probably predated the accident. That was his finding. That was the defense in this case. So we got into all these MRIs, and in this you can break these down, and you can show all the various, you can go deeper and deeper into it, and this starts with contusions. But when you get to the sagittal view on this one, what you see is a void in the splenium of the corpus callosum. So what you have is a hole in the brain, in the part connecting the two hemispheres. Now, that may have a little something to do with the stumbling too. So this is the graphic, which you can do, but then this is the actual MRI here, and that shows up rather graphically. So the next thing, we brought this young lady down, and we had, this was just becoming, we brought it down to Texas Children's. This case was in Arkansas. I had this big 18-wheeler case in Arkansas. And I brought this young lady down. I called the doctor over here who was doing the DTI at the time, and I said, look, I got a perfect case for you. And she said, bring her on down. So we brought her down, and I wish this showed up better. This shows up beautifully graphically on the originals, but it doesn't translate to slides to this very well. So it's much too dark, but you can probably see it. This is your normal brain fibers of the 8-year-old. You see the colors in here? What they've done is they've color-coded the brain fibers. So this is your normal 8-year-old, and you can turn this around and you can see it from all sides. Okay? Now, this is our client, And you see what's happening here? There's a void here, there's a void here. And this is where the brain fibers are dead, basically. And then we can turn that around and we can show it, and we can stop it wherever we want to. So this is the DTI. So we brought this down, and then the result was just, I think, excellent. It's a beautiful illustration. This is your PET scans, and the way we show this is just by pulling out markedly decreased F18, so forth. And then the same thing on the SPECT scans here. So we created those. Now, I've worked for years in these mild brain injury cases where I was trying to figure out the most effective way to convert a neuropsychologist report. We get neuropsychologist report, and it's a lot of paper this thick. And it has a lot of names and a lot of tests and a lot of this and a lot of rather simplistic tests, it appears. So, but you would absolutely bore boomers and Gen Xers and everybody else with that. And I say that from experience. But Generation Y would never even, you try to get the millennials to sit and listen to a neuropsychologist tell you about the brain injury to this child or to anybody, and they're not going to do it. So you got to find a way to get it, make it interactive, to make it so you can, it's all, third grade school teachers figured it out a long time ago. It's all about show and tell. And so you really have to show and tell with more emphasis on the show. So I worked with Dr. Pollock and with Dr. Lilly and with High Impact Graphics in Denver, and we came up with this method of showing the neuropsychological testing. You notice down here, this is severe deficit, moderate deficit, mild deficit, low average, average, high average, superior. Now up here are each one of these are the various types of tests. So what you do is you put, again, you can get your doctor to the stand and stand there and point to each one of these and explain it, and they become the educator. So first the doctor explains what the intellectual functioning test, what these tests are, what they are designed to show. And then you notice down here in those testing, you have 1% sequencing speed, lowest first percentile of sequencing speed. The visual attention, 6th percentile. Processing speed, 8th percentile. Working memory. So you go through and explain what each one of these tests is, what it's designed to show, what does it mean to have 1%, to be in the first percentile in sequencing speed. Then you go through the next testing, the verbal learning. And these are the verbal learning tests, and 2 out of 3 are adverse. Then you go over to response inhibition and sustained and focused attention, and then you get to executive difficulties. And when you get to the executive function, this is about as severe as you can get in executive function. And they have this one here, particularly high. Oh, well, she's doing superior on that. No, wait. That's the at-risk concerns in daily living. So that's where you want to be down at 1/2, 1%. So by the time a jury starts seeing all this curl along here and see first percentile, 6th percentile, and so forth on all these, 3 percentile, 2, then they start getting the idea that this child does in fact have some brain injury. And this has been the best thing I've been able to come up with so far in terms of establishing what the nature and extent of the injury is in this type of situation. Your starting point for proving a brain injury is this. Before you prove anything else, you prove this. What is this? That's the vehicle. That's the vehicle. Now that speaks volumes. Without saying a word, that speaks volumes. That's the car. If you can make out what the car is like, it was hit head on by an 18-wheeler. So in the right front, you got the mother in the driver's seat. You got the child immediately seated properly behind the mother, facing backwards as they're supposed to be. You got the other child in the back seat. You got the father in the right front seat. But look at the nature and extent of the injury to that vehicle. So right off the bat, it becomes very easy to believe that there's some pretty severe injuries involved in here. We also prove up the surgeries. And surgeries don't seem, some of these surgeries, you say, well, we had a repair of an open, depressed, comminuted skull fracture and a placement of a ventricular drain. That doesn't sound like much, and it's really not until you see it and you have the child sitting in front of you and you see what it looks like, and they move. The jury gets a chance to see especially the drill bit making the hole in the skull. And they're watching this little girl sitting there and thinking about, okay, all this happened to her head. I mean, this is a simple surgery. But again, all these simple things add up because these are all things that the child endured. And these particularly come because people kind of grimace. We've shown these to focus groups, and people kind of grimace, start putting staples in the head and that sort of thing. But then when they take the drill and start making the burr hole, that always has a certain impact. The people kind of grimace when they get to the burr hole. And again, this is all part of what an 8-year-old child endured. And the reason she had to endure all this is because she had a traumatic brain injury. So this slight tendency to stumble from the neuropsychologist for the defense sort of fell apart on this pretty rapidly. When we got through with this, after this case was over, the defense lawyer asked me if he could use my graphics, if he could take this demonstrative evidence and use it to give a speech to the defense bar. I said, well, if you'll stipulate, if the conclusion of your speech is you better damn well settle with Howard Nations, you're free to use it at will. Any time you want to. We had other cases in here, and this is just to show we had 4 people, we had 4 injuries in here. The child was killed, and I think the size of the casket here just sort of tells the whole story. You don't need a lot more than that. We also did the calendar in here showing 83 days of blank pages. 83 years, I'm sorry, 83 years of blank pages for activities of daily living. Then there's another one here that I'll show you just for a moment. This is where you have the severe trauma and where you do the full body graphic. And I did the same thing here. She had diffuse axonal injury. She had the scalp hematoma. And again, we bring out everything. We illustrate everything, regardless of how slight it may be, because, you know, after a while, the jury starts seeing all this and it starts adding up. And but there are things in. Look at all these fractures. Each one of those little gray boxes, you can't see it from there, but each one of those gray boxes is a fracture, a fracture to the face, which again goes right back to is skull fractures or facial fracture, which goes back to if you got hit that hard in the face, you broke all those bones in the face, think of what you must have done to the brain. And then we covered arm laceration, femoral fracture. In the femoral fracture, you know, people talk about they put a pin in the leg to repair the fracture. We go through all these rib fractures, pneumothorax, sepsis, and then we get down to the surgeries. When people talk about, well, they put a nail, had a fixation of the nail in the leg, and that doesn't sound like much because a nail's something about that long that you drive with a hammer, right? No, not exactly. So we have to show what this actually consists of, making an incision, drilling up into the bone, putting this kind of nail. You know, the whole idea of drilling up in your knee and up in the bone. This doesn't look like that much fun anymore. So that's what a nail looks like. But if you take each one of these things and break them down, and each one of these is educational. each one of these tells people the nature and extent of this woman's injury. And each one of these also contributes substantially to her overall damages, but it doesn't leave much doubt at all that this lady was the victim of a traumatic brain injury. Remember this, try the case you have, not the case you wish you had. And so in his case, we didn't try to claim that he had a multi-million-dollar claim. We proved his case for what it was. And what he did have was executive function. He had damage to executive function. So then we were able to prove mostly gray lines all across, mostly gray, mostly up here, mostly high percentile. But then we proved that he was highly functional except where he wasn't. And where he wasn't were in these columns over here under executive function. Then we had to explain what is the loss of executive. Well, loss of executive function, as you know, can mean an awful lot of loss of coherence in your life. So that's how we approached a brain injury case, and how I think that we have to approach brain injury cases today. You have to involve your jurors today. You have to be interactive with your jurors today. They won't talk to each other, so they're sure as hell not going to listen to you. So what you do, and I finally figured this out, what you do is you determine what your message is for your final argument. And when the judge says, all right, Mr. Nations, you may proceed, you take your final argument and you text it to them. So I hope I've said something that will help you help your clients. Thank you very much.